Yeah. First things first is fine. Okay. What does it say? That no fine shall be imposed on an employee in respect of acts or omissions without previous approval of government. So if you have to impose a fine and say that I have imposed fine of 10,000 rupees, I'm going to deduct it from the wages of the employee who is entitled to 24,000 rupees, right? I'm going to deduct it as a fine, I've imposed it. Can I just do so at my whim? No. I have to take previous sanction from the appropriate government to impose a fine on the employer. Number one, I have to also lay down a notice. I have to tell that which are the acts, if the employee does, I will impose a fine, or which are the omissions that the employees, fails to do, and they will be subject to a fine. So employees need to know that ये करने से या ये नहीं करने से fine impose होगा. Okay. Then if I impose a fine on Megha, I have to give Megha an opportunity that Megha, this is the fine that I'm imposing on you. What do you have to say about it? Everywhere you will see that an opportunity to hear the other party needs to be given. Okay. This is because there must be some just cause. They want to justify their case, and it is principles of natural justice that you follow. Hear the other party before taking any action. Maybe that employee, it's not his mistake at all, and you're just arbitrarily imposing a fine. What if that comes out? Hear the employee. Okay. So if you have to impose a fine, what do you have to do? Take approval. Display to the employees that what is the consequence of an act, what is the consequence of those omissions, and you have to give them an opportunity. Very important, total amount of fine which may be imposed in one wage period. One wage period could be maximum 1 month, correct? So if I'm entitled to 20,000 rupees salary, maximum what can be imposition of fine, which is 3%. I can't be imposed upon a fine of more than 3% as per Payment of Wages Act. Okay. Then if there is an employee who is below the age of 15 years, I can't impose a fine as an employer. Okay. Every fine shall be deemed to have been imposed on that day. So if I'm imposing a fine, it should be on that day only. Okay. Very important, this is something that you will find across provisions, is that whatever is the deduction that is being made, irrespective of the nature, it is because absence of duty, because of amenities, because of fine, you need to maintain it under a register. Okay, so record purposes. So if you see, all fines and realizations thereof shall be recorded in a register to be kept by the person responsible under section 3. Section 3 is saying whose responsibility is it to pay wages. So for factory, it is manager, railway, it is so and so. Correct? So this is number 1, valid deduction, fine. Okay. So quick recap of imposition of fine is that 1, you need approval of the government. 2, there has to be a notice specifying acts and omissions which should be exhibited and which will tell that if these acts happen, there will be fine. Very important, you have to give the employee an opportunity to show cause, why, explain why so and so act took place. Total amount of fine in one wage period cannot exceed 3%. No fine can be imposed on a person below the age of 15 years, and all fines and realizations thereof shall be maintained in the register by the person who is responsible for payment of wages. Okay, that's your number 1 deduction. We have 6. Okay, then going to deduction for absence of duty. Okay, this is given under section 9. What does this say? It's very simple, that if somebody is absent from work who is supposed to come to work, you can have a deduction in their salary. Okay, this is a little complicated language. Okay, it says the amount of deduction shall in no case bear to the wages payable to the employee person in respect of wage period for which deduction is made a larger portion than the period for which he was absent of the total period. It's a little complicated, so I'm just going to give you an example and tell you what this actually means. First thing to understand is that if there is absence in duty, there should be clear absence, that okay, the employee was supposed to come on a Monday and they thought Monday is a holiday and they did not come, so we are entitled to reduce their wages. Okay. Second thing is that you cannot surpass the total which bears a similar relationship. So example is that let's say compensation of the worker is 6,000 rupees. Okay, every month the worker earns 6,000 rupees and he is actually missing for a period of 1 month. Okay, what can you impose? If there is absence in duty, you cannot impose a deduction more than what he is entitled to. So he is entitled to 6,000 rupees. You can't say that I'm going to deduct 7,000 rupees from you for absence in duty. So whatever period of absence is there, that cannot surpass your monthly maximum. My monthly maximum is 6,000 rupees. I can't surpass that as a valid deduction for absence in duty. I'm absent for 10 days. You can't say that I'll deduct 7,000 rupees for this. No. Okay. So whatever is my monthly maximum, that has to be followed, and your deduction has to be below that. This is a deduction for absence in duty. Okay. Moving on to deductions for damage and losses. Okay. This is also very simple. It says that a deduction under so and so clause shall not exceed the amount of damage. Of course, if I have caused damage of goods which are worth rupees 10,000, the amount of sum that should be recovered from my employer should be 10,000. They can't say that I will recover 20,000 from you because there is XYZ thing, right? What is the actual amount? You have the right to deduct that. Okay. So whatever is the actual amount of damage or loss, you are entitled to recover. Okay. Again, if you see, you have to give the employed person an opportunity of being hurt. Probably the damage was not to their direct cause or not to their neglect, or in fact they exercised due diligence, but they still could not protect the property from being damaged. What in that case, right? So you have to tell them that you have an opportunity. Tell yourself, represent your case, and why should this deduction not happen. Okay, like I said again, that whatever damage is there, if you are deducting anything and if you're realizing anything from the employee, you keep it in the register. Very simple. You are going to deduct amounts, you have to maintain a register. There is recovery or there is realization, you have to maintain it in the register. Okay. So 3 deductions we have seen: fines, then deductions for absence of duty, and then third is deduction for damage or loss. Okay. Very simple. Deductions for services rendered. Okay. So here if you see, deduction unless HRA, amenity or service has been accepted by him. Basically, if employee has actually taken your HRA, has actually accepted your service, and this is as a term of employment, you deduct it. Okay. It should not exceed the amount of HRA. If you have, common points that you will find throughout deductions is that whatever is the loss, whatever is the actual amount, you're entitled to recover that. Most cases you will see that employee should be given an opportunity of representing themselves, and that you have to maintain it in the register. These are the common things you will find across deductions. That is the same for services. If I have actually taken house accommodation, if I have actually utilized the service, this is a part of my employment, very well deducted. If you have deducted it, just keep a record of it. Correct? Same for recovery of advances. Okay. Whatever recovery you do, it has to be on actual amount and it has to be maintained in registers. Okay. This is about your valid deductions under the Act. Okay.